You, the Honorable Speaker, as granted by you and requested by Senator Ojienda, this is question number 113 to ask the Cabinet Secretary for Labor and Social Protection. Question 1, could the Cabinet Secretary explain the rationale behind discharging workers in state-owned industries, particularly in strategic sectors such as sugar and textile industries, and how these decisions comply with Articles 41 and 43 of the Constitution on fair labor practices and the right to social and economic security, respectively. Question 2, could the Cabinet Secretary confirm the number of workers affected by the restructuring carried out in Kisumu County, especially in Chemelil, Muhoroni, and Miwani sugar companies, and clarify whether they have received full severance benefits, pensions, and gratuities without undue delay? Question 3, did the ministry conduct socio-economic impact assessments before approving the releases, and if so, table the reports and indicate the mitigation measures for affected households and host counties? Question 4, what immediate program has the ministry introduced to reskill, redeploy, or otherwise safeguard the livelihoods of the affected workers, and how the effectiveness of these programs is being monitored? And lastly, Honorable Speaker, on this question, how does the government intend to reconcile fiscal reforms with its constitutional duty under Article 232 of the Constitution on transparency, accountability, and responsiveness to prevent economic dislocations in counties that rely on state-owned industries? Thank you, Honorable Speaker.
Now, Honorable CS, I note that your response is fairly long. Since the same has been circulated to all honorable senators, you may wish to paraphrase it so that we save on time. You may proceed to respond, Honorable CS.
Thank you. Good morning, Mr. Speaker, sir, and honorable members of the Senate. I have a very comprehensive reply, but I'll try to make it, condense it, because there's a lot of repetition in terms of the facts. Let me start by giving a background, because it is important, because it will enable members to understand where we're coming from and also answer many questions asked. Mr. Speaker, the government of Kenya, through the Kenya Sugar Board, the Ministry of Agriculture and Livestock Development, and the National Treasury and Economic Planning, initiated a leasing model for state-owned sugar factories as an alternative to full privatization. This strategic decision sought to revive the struggling sugar sector, which has long been central to Kenya's rural economy and food security. Mr. Speaker, under this model, Nzoia, Chemelil, Muhoroni, and Sony sugar companies were offered to private operators for lease. As you are aware, Mr. Speaker, they had ceased operating properly. The objective was to enhance operational efficiency, modernize production, and restore profitability to ensure long-term sustainability of the industry. The government, this is very important, Mr. Speaker, the government, mindful of the human and social impact of the restructuring, acknowledged that the transition could lead to redundancies among workers. Demonstrating its commitment to fairness, social justice, and compassion, it engaged the Kenya Union Sugar Plantation Workers, which is the recognized representative of employees, and entered into a memorandum of understanding on the 7th of May 2025. The MOU, this MOU between the government and the workers, provided a humane and lawful framework for managing the transition, anchored on the principles of dignity of labor, fair compensation, and industrial harmony. It outlined procedures for the retention, separation, and compensation of workers, and the payment of all accrued benefits in accordance with the law. Let me repeat that. All accrued benefits in accordance with the law, the payment. Key provisions in the MOU include, one, that the person coming in, the lessee, will retain the current workforce up to 12 months under existing terms. So they're not walking in and firing people. For a full year, they retain the workforce. Number two, after 6 months, the lessee is to identify staff for permanent retention and issue them with fresh contracts. Because definitely in any organization, there are people who really will not be adding any value to maybe the new work style, or maybe they will be overtaken by events. Number three, non-retained staff, and this is very important, Mr. Speaker, honorable members, non-retained staff to receive a fair and lawful exit package, including notice or payment in lieu, accrued leave, severance pay as per the collective bargaining agreement, and all salary and benefit arrears. The Ministry of Agriculture and Livestock undertook to settle all salary arrears, pension contribution and statutory deductions up to the handover date. Payments to be made in a phased schedule up to June 2026, and these have been ongoing very well. Dispute resolution was also clearly provided for through the transition committee, where both the workers and also the government, and even resolved through the Ministry of Labour for conciliation. It is important to underscore that the Ministry of Labour was not party to the leasing process. You know, it's a government, not just the Ministry of Labour. Where we come in is to ensure that we safeguard workers' rights, ensuring that all actions comply with Section 40 of the Employment Act, existing CBAs, and the terms of the MOU. Mr. Speaker, let me proceed to question one, now that I've provided a background for understanding. The question is what the rationale behind the process and whether it's covered by law. The ongoing restructuring process in state-owned industries is part of the comprehensive reform programs aimed at restoring efficiency, financial stability, and competitiveness among these corporations. Everybody knows in this country that the sugar industry had collapsed. Cartels had taken over. People had not been paid salaries for years. You know, farmers had cut down their sugar. So these are a government program to revamp the sector and provide economy and money to the pockets of the people of Kenya. The discharge of workers under this restructuring is guided by lawful redundancy procedures as outlined by Section 40 of the Employment Act. It provides safeguards to ensure fairness and transparency for effective workers. Now, part of the process that we have demanded at the Ministry of Labour as per the law is that, one, that the employer must notify the relevant union, its affected employees, and the Ministry of Labour of what they are doing. Has this been going on? Yes, in this case of Mumias. Number two, provide justification of the scope of the redundancy. Has this been done? Yes. Number three, pay statutory and contractual entitlements, including notice pay, accrued leave, and severance pay. Same, ongoing. The Kenya Union of Sugar Plantations, the recognized representative of the employers, had initially gone to court before this process where the MOU was agreed upon. The Ministry of Labour and Social Protection has a role to ensure that the redundancy process complies with Article 41 of the Constitution, Section 40 of the Employment Act, and the CBA in force. Mr. Speaker,